In this famous case of international law, the government of Nicaragua complained to the International Court of Justice that the United States of America was funding a rebel group known as the Contras with the intention of destabilising and potentially overthrowing the Nicaraguan government. The United States had little or no chance of defeating that allegation on its merits, for the simple reason that they really had been funding the Contras and attempting to destabilise the Nicaraguan government in order to prevent that nation from coming under the influence of the communist Soviet Union. So instead of defending the merits of the case, the United States argued that the court did not have the jurisdiction to hear the complaint. This tactic, and the decisions which followed it, led to the court making some important points about the nature of international law, and in particular the relationship between customary international law and treaty law. To tell the story, this case note will begin by discussing the Cold War and the reasons why Nicaragua was briefly so important to the United States. We will then trace the rise of the Sandinista government in Nicaragua and its ousting of the previous dictatorial government, whose supporters then fled and became the core of the Contras. We will look at the US support for the Contras and the Nicaraguan complaint to the ICJ. The initial response by the USA was that the International Court of Justice could not hear the Nicaraguan complaint because it arose under several treaties, and the case did not meet certain rules the USA had established if it was to appear before the ICJ on treaty matters. Nicaragua then turned to customary international law as an alternative basis for its complaint, and the United States argued that customary international law was no longer relevant. Ultimately, the United States was unsuccessful in its attempts to stave off the inevitable. The court ruled in favour of Nicaragua and imposed reparations which were never paid. Let's look in depth at the case of Nicaragua and the United States, also known as the Paramilitaries case or the Sandinistas case. To make any sense of this case at all, we need to begin with an understanding of the general time in geopolitics. During the Second World War, the largely democratic Western countries of Great Britain and its Commonwealth, France and the United States of America had been allied with the forces of the Soviet Union under the communist dictator Joseph Stalin to defeat Germany. There were massive differences in approach between the Soviets and the West, but these differences were put to one side to defeat the Nazi threat. As it became clear that Germany would be defeated, the leaders of Great Britain, the United States and the Soviet Union met at Yalta in modern Ukraine to discuss what the post-war world would look like. By this point, the Western Allies had taken back France and Italy and Holland and Belgium and pushed into Germany. The Soviets had overrun Poland, Czechoslovakia, Hungary, Romania, Bulgaria and Yugoslavia. It was also clear that the Soviets would be the first to Berlin. The parties at Yalta essentially agreed to divide Germany into zones and for the Soviet Union to have dominance over Eastern Europe. Realistically, there was nothing that the Western countries could have done to prevent that dominance anyway. Soon after the war, relations between the former Allies began to break down. By 1946, just the year after the war ended, British Prime Minister Winston Churchill famously spoke of an Iron Curtain having descended across the European continent, setting the communist East against the democratic and liberal West. The conflict, however, was a Cold War. Both sides did everything they could to avoid coming to conflict on a battlefield, especially after 1949, when the Soviet nuclear weapons program hit full swing. Instead, they had proxy battles, including actual wars in places like Vietnam, but also other contests such as the space race, where the Soviets put the first person into orbit and the United States responded by putting the first person on the moon, or battles for prestige at the Olympic Games, leading to massive Soviet cheating, and boycotts where the Americans refused to attend the Olympics in Moscow in 1980 and the Soviets refused to attend in Los Angeles in 1984. Soviet communism was expansionist. The Warsaw Pact of countries, including the Soviet Union, Albania, Bulgaria, Czechoslovakia, East Germany, Hungary, Poland and Romania, were firmly in the grasp of the Soviet Union. Yugoslavia under Tito had its own version of communism. There were attempts to spread into Greece, leading to civil war. Maoism sprung up in China and spread to Vietnam, Laos and Cambodia. The Soviet Union had influence further afield, for instance in Indonesia. And in the Americas, they had allies in the Cuban government, leading in 1962 to a crisis where it appeared the Soviets may have been able to station nuclear missiles just to the south of the United States. Holding back communist expansion was a key objective of American policy, all of which brings us to Nicaragua and the Sandinistas. Nicaragua is a small country in Central America, lying right across the arm which joins the two American continents. For Australian viewers, it is roughly twice the size of our smallest state, Tasmania, or just a little more than half the size of our next smallest state, Victoria. It is a poor country and primarily an agricultural country. The original inhabitants of Nicaragua were displaced by the Spanish Empire in the early 1500s, and they ruled until Nicaragua became independent in 1821. The rest of the 19th century was tumultuous, and then they were actually ruled by the United States from 1909 until 1933, when the United States was ousted as the result of a guerrilla war. That war and the American departure left a power vacuum, which was ultimately filled by Anastasio Somoza Garcia, the head of the National Guard. He became a strongman dictator, ruling outright from 1937 until 1947, and then by proxy until 1950, and then outright again until he was assassinated in 1956. His sons then ruled either directly or through proxies for the following 20 years. The regime was always brutally intolerant of dissent, but they could afford to be. The Somoza family had confirmed itself as close allies of the United States and fierce opponents of communism, even reaching an agreement for the United States to use Nicaragua as a potential nuclear launch base against Cuba during the Cuban Missile Crisis. Repressive governments almost inevitably give rise to dedicated opposition groups. The most prominent of these was the Sandinistas, who took their inspiration from Auguste César Sandino, who had led the independence movement against the United States in the 1930s, but had been displaced and assassinated by Somoza. At first, the Sandinistas were ideologically incoherent, a diverse group mainly united by their opposition to the Somoza family dictatorship. They gained traction in 1972 when an earthquake caused massive damage to Nicaragua and the Somoza family diverted aid funds for their own personal enrichment. The Sandinistas stepped in to help the people. They also came to the attention of the Soviet KGB. Whilst never formally allied with the Soviet Union, they received training and support and general inspiration, and certainly by being anti-Somoza, the Sandinistas were anti-American almost by definition. In 1978-79, the Sandinistas stepped up their revolutionary efforts. Both sides were responsible for atrocities, kidnappings, extrajudicial killings, pillage. In the end, though, the Sandinistas prevailed, and the United States was suddenly faced with an unfriendly, left-leaning government with communist links just 1,000 kilometres or so from Miami. At this point in the Cold War, Nicaragua suddenly presented a big problem. Initially, American President Jimmy Carter from the more centrist Democratic Party took a fairly moderate approach to the Sandinistas. Nicaragua was in economic disarray, and the United States sent substantial amounts of financial aid to help restore the nation. In 1980, though, Republican President Ronald Reagan was elected, and he took a much harder line. The Americans found potential allies among Nicaraguans loyal to the Somoza family, and particularly former members of the National Guard. Many of these had escaped northwards into the neighbouring country of Honduras, where they formed themselves into a group simply named the Counter-Revolutionaries, in Spanish the Contra-Revolucionarios, abbreviated to Contras. Reagan moved to support them to overthrow the communist-inclined Sandinistas. There was not a lot of support within the United States for Reagan's plans. This was less than 10 years after the Vietnam War, and there wasn't a lot of enthusiasm for the United States to become involved in another war. There was also a perception, particularly among the Democrats, that Reagan was really proposing meddling in the internal affairs of another country. The Democrats tried to pass legislation in Congress forbidding the president from funding the Contras, but this effort failed. Instead, in 1982, they did manage to pass two amendments known as the Boland Amendments, which said that the president could not supply the Contras with money or arms for the purpose of overthrowing the Nicaraguan government, but they could do so for other purposes. This was enough of a loophole for Reagan. He couldn't overtly use the US military, so instead he tasked the Central Intelligence Agency, the CIA, to assist the Contras. Weapons, money and training were all funneled to the Contras by various illicit means. The campaign faced some huge problems though. For one thing, very few Nicaraguans looked back nostalgically at the period of Somoza family rule, and so the Contras had limited support in Nicaragua itself. They were also militarily unsuccessful, unable despite several attempts to cross the border and establish a key foothold in Nicaragua. At some point, the objective of the CIA and the Contras seems to have changed from overthrowing the Sandinistas to just creating chaos. The United States helped the Contras to build airfields in Honduras from which they could fly guerrilla fighters all over Nicaragua. They attacked coffee production in particular, which caused massive damage to state-owned coffee plantations, which in turn severely damaged the Nicaraguan economy, coffee being one of its biggest exports. The Contras also did things like laying mines in key ports to prevent commercial shipping from moving in and out of Nicaragua. None of this was likely to endear the Contras to the people of Nicaragua, but one suspects that from the CIA perspective, a poor, unstable Nicaragua with a failing communist-aligned government was much better than one which was flourishing and which could provide the Soviet Union with a useful ally. This was the context in which the Nicaraguan government made its application to the International Court of Justice. We'll come to that application shortly, but first it's necessary to make some brief observations about the relationship between the United States and the International Court of Justice. The International Court of Justice, or ICJ, sometimes referred to as the World Court, was created by the Charter of the United Nations, which was agreed in principle just weeks after the defeat of Nazi Germany and before the surrender of Imperial Japan. The court was essentially the successor of the Permanent Court of International Justice, which had been an organ of the League of Nations formed after the First World War, which itself was a successor to an earlier body called the Permanent Court of International Arbitration. The ICJ then got its own statute, which was passed along with the UN Charter and which set out the court's basic functions and procedures. Although we refer to it as a court, the ICJ has a number of very important differences to the court institutions we're familiar with in Australia and round the world. For one thing, the purpose of the ICJ was to settle disputes between countries, so the litigants before the ICJ were to be nations. A second and more important characteristic is that the ICJ does not have any inherent powers or jurisdiction. A national court has compulsory jurisdiction. If you are called before the court, you must answer the summons of the court, or it will issue a warrant and you will be arrested and brought before the court. Well, that doesn't work when the parties are sovereign nations. The United Nations, and hence the ICJ, have no sovereignty. Their only power comes from the consent of independent nations. Countries can therefore only be brought before the court if they have consented to the jurisdiction of the court. The United States was a signatory to the court's statute. However, a central element of the political philosophy of the USA is the concept of American exceptionalism. In other words, the United States tends to believe that the rules of international law should apply to everyone except the United States. On this view, the USA is bigger and better and more important, and the USA is profoundly unlikely to behave in an evil way, and so there is no need for courts and similar institutions to apply to the USA in the same way they do to other countries. When the United States signed up to the ICJ, when they signed and ratified the ICJ statute, they entered a number of reservations to their signatures. Reservations are an interesting phenomenon. They allow a country to agree generally with a treaty, but then allow that country to carve out from their agreement any bits that they don't agree with. The Americans entered 3 reservations. Those were, first, that disputes should not be referred to the ICJ if they were already before some other tribunal. Seems reasonable. Second, that the ICJ should not issue judgment for matters which the USA considers to be internal matters. Third, and for our purpose most important, that if a claim was made against the USA and the claim was made under a multilateral treaty, that is, a treaty involving more than 2 countries, the ICJ could only proceed if all affected countries were part of the case. This reservation was phrased as follows, stating that the ICJ would not have jurisdiction over the USA in disputes arising under a multilateral treaty unless 1. All parties to the treaty affected by the decision are also parties to the case before the court, or 2. The United States of America specially agrees to jurisdiction. So, why does this matter? To find out, we begin with the application to the court made by Nicaragua. It began as follows. The United States of America is using military force against Nicaragua and intervening in Nicaragua's internal affairs in violation of Nicaragua's sovereignty, territorial integrity, and political independence, and of the most fundamental and universally accepted principles of international law. The United States has created an army of more than 10,000 mercenaries, many of whom served the former dictator Anastasio Somoza Debayle, installed them in more than 10 base camps in Honduras along the border with Nicaragua, trained them, paid them, supplied them with arms, ammunition, food and medical supplies, and directed their attacks against human and economic targets inside Nicaragua. Of course, there seemed little doubt at the time, and there's even less doubt now, that this was all true. Nicaragua claimed that by doing all of this, the USA had contravened no less than 4 separate multilateral treaties. First, they said that the American conduct contravened Article 2 of the Charter of the United Nations, which says all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Then they turned to the Charter of the Organisation of American States, to which the USA was a party, and Article 18 of which said, no state or group of states has the right to intervene, directly or indirectly, for any reason whatsoever, in the internal or external affairs of any other state. The foregoing principle prohibits not only armed force, but also any other form of interference or attempted threat against the personality of the state, or against its political, economic and cultural elements. Third, they turned to the Montevideo Convention, more formally known as the Convention on Rights and Duties of States, adopted by the 7th International Conference of American States, a convention signed back in 1933, Article 8 of which said, no state has the right to intervene in the internal or external affairs of another. Finally, they called on the Convention concerning the duties and rights of states in the event of civil strife, an even earlier treaty signed in 1928 at the 6th International Conference of American States, which required member states to prohibit the exportation or importation of any shipments of arms and war material intended for starting, promoting, or supporting civil strife in another American state. Of course, this is all pretty damning stuff. If the ICJ was allowed to determine this claim on the merits, the United States was not going to come out well. So the United States relied on its reservation to the ICJ statute. They said that the ICJ could only have jurisdiction if all affected countries were involved in the proceedings. They argued that the neighbouring countries of Honduras, El Salvador and Costa Rica were directly affected by the proceedings, but were not part of the proceedings, and so the ICJ lacked jurisdiction. The American memorial or written argument put it this way: Nicaragua's application, together with its memorial and its other submissions to the court in this case, make clear that other Central American states would be affected by the court's decision in this case. With respect to Honduras and Costa Rica, this is indisputable on the face of Nicaragua's application. The public statements of Salvadoran leaders establish that El Salvador too will unquestionably be affected in a legal and practical sense by the adjudication of Nicaragua's claims. Because Honduras, Costa Rica and El Salvador are parties to each of the 4 multilateral treaties on which Nicaragua relies, the United States multilateral treaty reservation precludes the court's jurisdiction over Nicaragua's claims. This was a strong argument, and it's perhaps somewhat puzzling that the Nicaraguan side didn't see it coming and invite those countries to participate. Their participation could hardly have weakened Nicaragua's case, but they did not. The court itself seems to have realised this, saying in its judgment on jurisdiction, the court would observe further that all 3 states, Honduras, Costa Rica and El Salvador, have made declarations of acceptance of the compulsory jurisdiction of the court, and are free at any time to come before the court if they should find that they might be affected by the future decision of the court. The court, to its discredit, then undertook some linguistic gymnastics. They focused on the words parties to the treaty affected by the decision. Let's have a look at the American reservation again, just to put those words back in context. The reservation removed jurisdiction in the case of a multilateral treaty unless 1. All parties to the treaty affected by the decision are also parties to the case before the court, or 2. The United States of America specially agrees to jurisdiction. The court found that it would not be possible to know which countries would be affected by the decision of the court until the court's decision was made. As a result, they found that they had jurisdiction to hear the application of Nicaragua. The court put it this way: by way of example, we might take the hypothesis that if the court were to decide to reject the application of Nicaragua on the facts, there would be no third states claimed to be affected. Certainly the determination of the states affected could not be left to the parties, but must be made by the court. This reasoning is not at all convincing. Essentially what the court was saying is that the court wouldn't know if it had jurisdiction to hear the matter until after it had heard the matter, that it would not know whether it had the power to compel the United States to come before the court until after it had already compelled the United States to come before the court. It was circular reasoning, and the government of the USA was no more convinced than I am. Judge Schwabel, the American judge on the panel of judges hearing this matter, made the argument brilliantly. He said, "It goes without saying that if identification of affected nations can be made only at that late stage, after the parties have been required fully to brief and argue the merits, the reservation could not fully serve the purposes of a jurisdictional bar which it was designed to serve. In my view, such an interpretation of the multilateral treaty reservation is unacceptable. It is not the function of the court to interpret the reservation of states so as to lead, if not to a result which is manifestly absurd or unreasonable, then to a result which denies a reservation its obvious object." Judge Schwabel's reasoning was not supported, however, and the matter proceeded. It proceeded without the United States. As the United States considered that the court had no jurisdiction to deal with the matter, the United States refused to participate further in the trial, leaving Nicaragua to stand unopposed. Ultimately, the court returned to the question of the treaties. Essentially, having heard the trial, the court returned to the question of whether it ought to have heard the trial. And it found in essence that the US argument was right. It found that El Salvador at least was an affected country, and so the court lacked jurisdiction to hear Nicaragua's treaty-based complaints. In that final judgment, the court said, "The court finds that El Salvador, a party to the United Nations Charter and to the Charter of the Organization of American States, is a state which would be affected by the decision which the court would have to take on the claims by Nicaragua. Accordingly, the court concludes that the jurisdiction conferred upon it by the United States does not permit the court to entertain these claims." Luckily for the court, however, in addition to making applications under the 4 multilateral treaties, Nicaragua made applications under customary international law. To make sense of this, I will need to spend a few moments talking about what customary international law is. In general, international law is created in 3 ways. The most common way in modern times, and the method most people are most familiar with, is by 2 or more nations concluding a treaty, which is really something more like a contract or a deed. Essentially, it's a promise whereby each country agrees to abide by the terms of the treaty in return for each other country also agreeing to abide by the terms of that treaty. Stack all these treaties on top of one another and you get, essentially, a body of law. The second method, which I won't dwell on very much here, arises from the writings of the most learned academic professors. This is rarely used these days. Third, international law can be derived from what is known as customary international law, or the general practice of nations towards one another, where that practice has reached the point that it is regarded as creating obligations and not just courtesies. This reflects the fact that for many years prior to the development of a formal system of international law, countries, kingdoms and empires had begun dealing with one another and had worked out ways of doing so. An easily understood example is the white flag used to indicate that a person is not part of a battle, whether because they are a civilian trying to flee, or a fighter trying to surrender, or a fighter seeking to negotiate a truce. White flags are now written into treaties as a form of protected symbol, but white flags have in fact been used for centuries to indicate that a person wanted to surrender or negotiate. so you can see that there was a customary law for centuries before that law was written into treaties. Customary law still exists, and in some senses customary law is still being made, if countries deal with one another in ways that are not yet described by treaties. So returning to the current case, in addition to its complaints under the 4 treaties, Nicaragua complained that the conduct of the United States had breached its obligations under customary international law. It claimed that general and customary international law placed the United States under the following obligations which had been breached: an obligation to respect the sovereignty of Nicaragua, an obligation not to use force or the threat of force against Nicaragua, an obligation not to intervene in the internal affairs of Nicaragua, an obligation not to infringe the freedom of the high seas or interrupt peaceful maritime commerce, and an obligation not to kill, wound or kidnap citizens of Nicaragua. The United States responded in 2 ways. They argued that these allegations under customary law merely restated the principal Nicaraguan complaints under treaty law. And they argued that because the treaty law in these areas was so comprehensive, in essence there was no more customary law. Customary law had all been overtaken by the treaty law. Their memorial stated, Nicaragua's allegations based on general and customary international law are no more than restatements of Nicaragua's assertions that the United States has violated the Charter of the United Nations and the related provisions of the Organization of American States Charter. The United Nations Charter, moreover, subsumes and supervenes other sources of international law in this area. The United Nations Charter, in effect, is the customary and general international law with respect to questions concerning the lawfulness of the use of armed force. The court will not, therefore, be able to consider Nicaragua's customary and general international law claims without interpreting, construing, and applying the multilateral treaties on which Nicaragua bases its principal claims, in particular the Charter of the United Nations. This leads us to what has become recognised as the key issue resolved in this case. When there is an area of international law based on customary international law, and then a major multilateral treaty is developed covering that same area of law, what happens to the customary law? Is it supervened and essentially overwritten, or does it remain valid, sitting alongside the written treaties? This was an important question which required detailed and subtle legal analysis. And whilst this case note has been critical of some aspects of the court's reasoning in this matter, the reasoning put forward by the court on this point seems quite sound. They dealt with the question in 2 ways. First, they asked whether treaty laws in this case covered exactly the same ground as the customary international law. And second, they considered whether customary international law could remain intact even if the 2 types of law did cover exactly the same ground. These 2 approaches will be dealt with one by one. On the first point, the court noted that as regards the suggestion that the areas covered by the 2 sources of law are identical, the court observes that the United Nations Charter, the convention to which most of the United States argument is directed, by no means covers the whole area of the regulation of the use of force in international relations. On one essential point, this treaty itself refers to pre-existing customary international law. This was crucial. You see, Article 51 of the United Nations Charter starts with this: nothing in the present Charter shall impair the inherent right of individual or collective self-defence if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. That provision can only have any meaning at all if there is an inherent right of individual or collective self-defence. and if such an inherent right exists, it can really only be a customary right, a matter of customary international law. So here was the keystone multilateral treaty, quite clearly operating in cooperation with customary international law. It was therefore impossible to say that the two were identical, which suggested that customary international law was still intact, almost like a layer of law underpinning the multilateral treaty. However, so what? Even if there were little remnant bits of law where the customary law had not been overtaken by treaty law, it remained the case that most of the areas referred to by Nicaragua in its customary law claim were well and truly covered by treaty law. So what of them? Well, the court found that even when the treaty law and the customary law cover exactly the same ground, there's no reason why they couldn't coexist. The court said there are a number of reasons for considering that even if two norms belonging to two sources of international law appear identical in content, and even if the states in question are bound by these rules both on the level of treaty law and on that of customary international law, these norms retain a separate existence. They then expanded on those reasons. Really, there were two. The first basis was that treaties almost always contain conditions whereby the treaty might be suspended or terminated, or mechanisms for one party to suspend its obligations under the treaty, usually in circumstances where they allege that the other party has not met its obligations. What should happen in that situation? If the treaty is suddenly suspended, does that mean the rules disappear altogether? Wouldn't it make more sense for the underlying customary rules to remain applicable, so that they could still be relied on if for some reason the treaty cannot? This is a sensible proposition, and one which is similar to the common law rule that statute might overrule the common law, but does not extinguish it. Second, the court noted that treaties often don't just make rules, they also create institutions to interpret and administer those rules. So even though the treaty rule might be the same as the customary rule, they might be enforced by different institutions. If this is the case, then it's no longer really true to say that they're the same rules, because the parties may have different procedural rights and different methods of enforcement. And there's no automatic reason why a party, by signing up to a treaty, would be agreeing to give up its ability to approach the institutions which enforce the customary law. These were both good arguments, but the final blow for the American argument came when the court said this: however, so far from having constituted a marked departure from customary international law, which still exists unmodified, the United Nations Charter gave expression in this field to principles already present in customary international law, and that law has, in the subsequent 4 decades, developed under the influence of the Charter to such an extent that a number of rules contained in the Charter have acquired a status independent of it. In other words, the court found that not only could customary international law coexist with treaty law, the court found that treaty law could so fundamentally change the way that nations dealt with one another that the treaty law could actually become customary law, having a life and value of its own, independent of the treaty. Having thus decided that the court could hear Nicaragua's complaints insofar as they relied on customary international law, the court considered the evidence. Naturally, the evidence was pretty one-sided, since the Americans were not participating in the trial. Unsurprisingly, the court found that all of the charges against the United States were proved, and that the United States should pay reparations in an amount to be agreed. Equally unsurprisingly, nothing was ever paid. Instead, the United States launched a preemptive strike, and on the 7th of October 1985, it gave the required 6 months' notice that it was withdrawing from the compulsory jurisdiction of the court. That, as of the 7th of April 1986, it would only appear before the court by its own consent. The main judgment on Nicaragua's claim came down after that date. It's hard to escape the view that the United States only supports the ICJ when the ICJ supports the United States. A few months after the judgment, things got even stickier for the United States. Remember that the Congress had forbidden the president to support the Contras, even though everyone apparently knew it was happening. The congressional position, however, meant that money to support the Contras couldn't just blandly appear in US budget documents. Instead, in late 1986, it emerged that from 1981 until 1986, the United States had been illicitly selling weapons to the Islamic Republic of Iran and siphoning the proceeds to fund the Contras. The Iran-Contra affair was a major scandal, resulting in the conviction of a range of senior people, including the US Secretary of Defense and the senior-most national security advisor, both of whom were pardoned by President Bush Sr. With the US funding for hostilities removed, the Contras hung on for a while, but in 1990, the war between the Contras and the Sandinistas ended with a ceasefire. In that same year, the Sandinistas were the surprise losers of a general election and were ousted from office, the voters accomplishing what the Contras could not. The Sandinistas remained in opposition until 2006, when they were re-elected under Daniel Ortega, who had been the president when they lost in 1990. Since 2006, he has gradually increased the politics of repression in Nicaragua, cracking down on pro-democracy protesters ahead of a rigged 2018 election, and then prohibiting any serious opposition from running against him in the elections of 2021. Since the end of the Cold War, however, Nicaragua has been insignificant from the perspective of world geopolitics, and it remains one of the poorest countries in Central America. There are two key legal principles established by this case. The first is that customary international law is not extinguished by treaty law, not even if the treaty law covers exactly the same ground as the customary international law. Even though the treaty law might well become much more prominent, the customary law remains intact and can, if necessary, be relied on by the courts. In particular, if the treaty ceases to operate, or if for some reason the treaty cannot be given effect, then the underlying customary international law will spring back into significance. The second key point is that once a treaty is sufficiently widely observed and sufficiently significant, it may be that the treaty itself establishes propositions of law which can become customary law. So a treaty can actually generate new customary law. Finally, perhaps inadvertently, this case demonstrated yet again the inherent weakness of international law. Because international institutions have no sovereignty, their processes and decisions are not enforceable, and they can be safely ignored by any nation with the clout to do so.